Hi, Sherry Renner here with Law U America, and this is one of our videos in the series Legal Abuse as an Extension of Domestic Abuse. And this is October 2014, which is Domestic Violence Awareness Month. And with us today, we have Victoria Vilchez. Victoria is the owner and managing attorney for Victoria Vilchez, PA. She was admitted to the Florida bar in 1980 and has focused her practice primarily on family and juvenile matters. Ms. Vilchez is a native of Florida who received her BA degree from Florida State University and her JD from Mercer University. She is admitted to practice in the state of Florida as well as the southern and middle districts of Florida, and those are the federal courts. She is also a Supreme Court certified circuit civil and family mediator. Thank you for being here, Victoria.
Well, thank you, Sherry.
All right, so today we're talking about legal abuse as an extension of domestic abuse. And so you've had a long career as a family law attorney. Have you ever been involved in representing parties or litigating against parties who have been committing legal abuse?
Well, you know, legal abuse is, I think, probably a fairly recently coined term, but there is no question that that's exactly what it is. There have been times where, for example, a potential client would come into my office and bring me just reams of paper that had been going on in the case that they were, say, already in the middle of or down the road from. And it became clear upon reviewing those documents that this was definitely a case of the other party, the other individual, and or his or her attorney, if there was one, utilizing the legal system, the justice system, to do some harm or damage, sometimes from a very psychological, emotional perspective. In this case, we're not talking about the physical abuse, but we are talking about the very real emotional, psychological abuse that someone faces when they are in extended litigation.
Okay, so you said legal abuse is something that's been recently coined, a recently coined term or expression. Was there a name for it before it was called legal abuse?
You know, I think that most of us, it's one of those you know it when you see it kind of things, would say, you know, this person is just really misusing the system, or, you know, they're abusing, you know, what the law allows. But I never really, until I'd say the last maybe year or two, actually thought of it or heard of it as an actual phenomenon that you put a name on it. And I think that's true for a lot of different things. You know, physical abuse went on for years before someone actually put a name to it and sort of put a spotlight on it. So I think that this is now putting a spotlight on something that many of us have seen going on for probably most of our careers, but there wasn't a specific name that everyone gave to it. But again, it's something that has been out there for quite a long time.
Okay, so kind of building on something you said just a moment ago, there's a proper use of the courts and an improper use of the courts is what I hear you saying. So that in a legal abuse scenario, somebody is in court and using the courts to do something other than what the courts are there for. What the courts are there for are to resolve disputes, you know, using the laws to resolve disputes. And so there's something else that's going on, an additional or an overt agenda to use the courts for an improper purpose, which, as you said, was to cause some harm to the other person.
Right. And, you know, interestingly, what comes to mind is, you know, the difference is in the intentions and the motives of the party that's perpetrating what we're calling abuse. You know, because people do have a right, as we know, under the Constitution, to seek redress, to seek assistance in resolving their disputes. It's a constitutional right. And certainly in the area of family law, marital and family, paternity issues, when parties can't resolve the issues on their own, or they believe they need the assistance of the court system, then they certainly have a right to do that. And there's a whole host of processes and procedures in place that allow for this sort of an orderly resolution. We have rules of discovery, we have methods, we have processes like mediation, we have pretrial hearings. All of these are in place to assist the parties in moving their matter forward. And yet in the case where someone has, shall we say, less than pure motives, they are able to use this. That is a good, that we have procedures for orderly resolution in place. They can utilize it to achieve what they may not even, Sherry, let's say it, they might not even really acknowledge that that is their purpose, is to cause harm to the other party. In their mind, they are seeking to have their voice heard or to have things go their way. But whether it's intended or not, the result is that harm does come to the other party and very often to any children that may be involved.
Okay. As an attorney, are there any hallmarks that you see that arise during part of the litigation that gives you an indication that you're involved in a legal abuse scenario?
Yes, in the example I gave you of someone coming in and there's just volumes and volumes right there, that's sort of a hint. When I go through the documents, very often I will see pleadings that appear to be more than just what you need to do to state a cause of action and get a hearing. You know, it may be embellishment, exaggeration, excessive dramatic effect, things that could be intended to strike fear, intimidation, or perhaps just hoping that the other party will just roll over and say, okay, fine, whatever you want, I'm tired of this. And very often we haven't really gotten into this yet, but very often, depending on the personality type of the individuals involved, the abuser, as we're calling this individual, may very well just really enjoy seeing the effect all of this has on the other party. Imagine, going to your mailbox, or if you're represented by a lawyer, having a lawyer send to you documents that say that you are a terrible mother, that you do this or you do that, or vice versa, that dad doesn't care about the children, et cetera, all calculated to create so many negative emotions in the other party. That, to me, when I see those kinds of things, that tells me that there is more than just a simple, I want to just address the issues.
Is there something as an attorney that you can do to help protect your client from these harmful effects of a legal abuser?
Well, depending on at what point I come into a case, some of the techniques that can be used are to pick up the phone. If there's another lawyer involved, pick up the phone, call the other attorney. Try to just have a, attorney to attorney conversation about how can we help to resolve these issues for these parties. Can we go into mediation? Are there documents you need? Are there documents I need? What can we do to get it back on a track where we are focusing on the legal issues that need to be resolved? If there's no attorney on the other side, that complicates it a little bit, but there are still methods of going ahead and, if needed, bringing to the attention of the court that there seems to be a misapplication of the procedural rules and laws. For example, if someone keeps getting hauled back into court for hearing after hearing after hearing, something needs to be addressed on that. And the court needs to take a look at it and set some boundaries and set some guidelines. And in my experience, most judges have been willing to do that once it's brought to their attention.
Once it's brought to their attention, okay. And so it's something that needs to be brought to something that needs to be brought to the attention of the judge then by the attorney. Okay.
Right, because just as a general rule, judges are not actively monitoring these cases. If there are attorneys involved, the attorneys are expected to basically provide counsel and to move the case forward in an orderly, appropriate fashion. if that's not happening and there are attorneys involved, then it's incumbent upon the attorney representing the party that's being abused or being these pleadings or the method is harming them to go ahead and file an appropriate motion to bring it to the attention of the court. And when parties are unrepresented, it's basically on them, unless there's a case manager involved, it is on them to move their case forward and to bring things to the attention of the judge. The court generally only acts in response to something being filed and called up for a hearing.
And that's proper. That's the proper role of the judge. Okay. So we've talked a lot about court procedure and the judges and whatnot. Is there any way, because if you're filing for divorce, I mean, you necessarily have to go through the courts. Is that correct?
Well, not entirely. Yes, to the extent that it requires the judge signing an order to dissolve the marriage. Mm-hmm. But there are other ways of resolving the issues that generally arise between two parties when they are dissolving their marriage. One way is something that I'm very passionate about, is called collaborative divorce. Mm-hmm. And in that, the parties agree at the very beginning, at the outset, that they are not going to engage in that kind of litigation, that they actually sign a contract in which they agree that they will work through the legal issues that need to be addressed in a series of meetings and conferences. They generally have an attorney involved, and most often there is a facilitator who is frequently a mental health professional to help manage emotions, mm-hmm. and there would be a financial professional involved to help with any resolution of financial issues, children, houses, property, etc. But it's not two people going off and each hiring someone to do battle with the other side. It is, these are the issues, we need to get through them, everything's on the table, it's open and transparent. What do we need to do to get from this point to a resolution that we can all live with? To me, that is by far the best way to approach a case like this. But I'll tell you, in all honesty, it's not going to work in every single case. It requires two people that are at least open and willing and honestly capable of working through their issues in that fashion. And I'd say that's most people. Mm-hmm. But then there is that small subset of individuals that, for reasons that we've already addressed, that it may just be their personality type, it could be a mental health disorder, would much rather go through the litigation and all the strife that entails. Even in cases where parties start off filing paperwork and it looks like it could be contentious, very often you see those cases get resolved when the parties and their attorneys, or just the parties, sit down with a good mediator and are able to, in an informal setting, just work through and resolve issues. Mm-hmm. Those are some alternatives.
Okay. And you said that's collaborative divorce.
Collaborative divorce, right, is the first one I was talking about, yes.
Okay. Okay, but not necessarily something that can be utilized in every case. Okay.
Not at all, no.
Have you ever been representing someone in a legal abuse scenario? You know, the other person is abusing the courts to harm your client, and it got to the point where the client could no longer afford to pay the legal bills, and then was forced to represent him or herself going forward.
Absolutely. Yes, absolutely. And I've sometimes wondered if that was not perhaps one of the additional hidden items on the agenda of the other party, is, knowing that, the other party or their spouse, whatever the case may be, literally could not afford to continue. Mm-hmm. Because, the reality is, every time an attorney goes to court, there's preparation time, there's travel time, there's attendance at the hearing. Those costs add up very, very quickly. Mm-hmm. So the reality is, it becomes very costly. It can become very costly very quickly. And if I'm a party that, at least at the outset, has more of the funds, or has perhaps wealthy relatives that can continue to fund this seemingly forever, that can cause the other party a lot of problems. And very often I've seen people who great people, great clients, they just literally cannot afford to continue.
Yeah. Do you have any words of wisdom for people who find themselves in that situation, who are representing themselves?
Well, there are resources, and I would say the first thing is to educate themselves. It is not easy for someone that's not a lawyer. Tough enough for a lawyer to try to go through this on their own, but for someone that's not trained in the law to actually represent themselves when they have an emotional stake in the outcome, certainly makes it much more challenging and complex. But there are educational resources out there. I think Law U is a great resource for people. Also, something I've helped people do in my practice is to guide and coach people through what they need to do when they're representing themselves. I see that as a great need for people who can't afford or don't want to spend the money to have someone do everything for them, perhaps to assist them in preparing. For example, preparing for a deposition, preparing for a mediation. I've also assisted people who say just wanted me to appear with them for a mediation. That cuts down the cost, but it ensures that they have someone there with them to advise them when they really need it. So I think it's a matter of someone figuring out what their budget is, what they can afford, educating themselves, finding out what resources are available to them, and getting the coaching and the advice from someone that's a licensed practitioner, not just from friends down the street that went through it before, to assist them in being able to represent themselves as best they can.
So there's a lot of room in between full representation, where you pay an attorney to represent you, and going it completely alone. There's a lot of middle ground. So what you find and how you arrange that really depends on your budget and what you want as far as what you want to do for yourself and what you would prefer for somebody else to help you with.
Right.
Yeah.
Right. And I've had some folks say, I'm very well organized. I can get all the documents together. I can do this part. I can do that part. But I don't speak well. I get very nervous. So if you would just, come to the mediation with me so that I have someone that can say what it is I know how to say, but I'm not very good at it. Or, for example, they have a hearing coming up and they say, I have all the documents ready. I could walk in there myself, but I'm just not comfortable doing it because there's another attorney involved on the other side. So yes, there is so much that can be done in between those two extremes.
Yeah. And would you recommend someone to get a law coach, an attorney, to help them at least a little bit if they can afford it?
Absolutely. One way that I think is very cost effective is, for example, if someone is going to be going, for example, into a deposition or into a hearing, a coach, a lawyer who is acting as their coach, can help to prepare them. As a lawyer, I can anticipate, what the questions are going to be, even help someone to know, okay, here's how you'll be seated in the courtroom. Here's the procedure that's generally followed. Everything to lessen, the fear and the anxiety, and also to help them create their plan for how they're going to present their side of the case when the time comes in that setting. I think all those are extremely helpful.
Great. Thank you.
We thank Victoria Vilchez for her generosity in sharing her time and expertise with us. For more information about Ms. Vilchez and her law practice, please visit her website, vilchezlaw.com.